If you think the Supreme Court just wiped out every gun permit in America, stop right there. Because if you believe that headline and act on it, you could carry illegally in your own state without even knowing it. Quick question before we continue. Are you subscribed? Because what I'm about to explain could keep you from making a mistake that costs you your permit, your gun rights, or even a criminal charge. Hit that button now. Here's what just happened, and here's where the internet got wildly ahead of itself. A lot of people are throwing around the claim that the Supreme Court ended gun permits. That sounds huge. It sounds simple. And it sounds like overnight, every state became permitless carry. But that is not what happened. What the Supreme Court actually did in New York State Rifle and Pistol Association versus Bruen was strike down one specific kind of permit system. The court said New York could not force ordinary law-abiding people to prove some special reason or proper cause before getting a public carry license. In simple English, the court said you do not need to show you are extra special, extra threatened, or more at risk than other people just to exercise your right to carry for self-defense. That is a massive ruling, but it is not the same as ending all permits. And this is the first thing you need to understand. Most people hear one dramatic sentence and stop there. They never get to the part that actually matters. The court did not say permits are gone. The court did not say every state must allow permitless carry. The court did not say training rules, background checks, fingerprinting, and license forms are automatically dead. In fact, the court went out of its way to point out that many shall issue permit systems were still different from New York's old setup. Shall issue means if you meet the objective rules, the state must issue the permit. Objective rules are things like age, background check, fingerprints, and sometimes training. The key point is this: the official does not get to deny you just because they think you do not need it enough. That one difference changes everything. Before this case, in some states, the government had huge discretion. That word just means power to decide on a case-by-case basis. If an official liked your reason, maybe you got the permit. If they did not, maybe you were out of luck. The Supreme Court said that kind of system crosses the line when it blocks ordinary people from carrying for self-defense. Now, why should you care if you do not live in New York? Because this ruling did not just hit one state, it sent a message to every state in the country. If your permit system depends on a government official deciding whether your personal need is good enough, that system is in serious trouble. But here's the crazy part. A lot of people heard that message and turned it into something much bigger. They started saying, that means permits are over. No, not even close. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Let me break this down for you with real-world examples, because this is where it gets interesting. Imagine you live in a state that still requires a permit to carry concealed. You fill out an application, you do a background check, maybe you take a class, maybe you get fingerprinted. If your state uses those kinds of objective rules, Bruen did not automatically erase that system. You still need to follow your state law unless and until a court says otherwise or the law changes. Now imagine a different system. You apply, and the state says, tell us why you need to carry more than the average person. Maybe you say self-defense. They answer, that is not enough. Maybe they want proof of threats. Maybe they want police reports. Maybe they want you to show some rare danger. That is the type of setup the Supreme Court said was unconstitutional. See the difference? Most people think the case was about permits versus no permits. But the truth is, it was really about discretion versus objective rules. That is the second big thing you need to remember. And here is why that matters for every state. If your state already had a shall issue system, the direct effect was smaller. If your state had a may issue system, where officials had broad power to deny permits based on need or good cause, the effect was huge. Those states had to change. Fast. That is why after Bruen, states like New York did not just give up. They rewrote laws. They changed standards. They expanded sensitive places. That term means places where guns can be banned, like certain government buildings or schools. And this is the part that shocked a lot of people. Some states lost one fight, then came back with new restrictions in different forms. So if you thought Bruen meant total victory in the end of the story, that was a mistake. Here's what most people get wrong. They think one Supreme Court ruling flips every law in America overnight like a light switch. Real life is messier. States resist, legislatures rewrite rules, lower courts step in, new lawsuits get filed, old laws get challenged again. So yes, Bruen was huge, but no, it did not end the legal war. Let's make this personal. Imagine you live in California, New Jersey, Maryland, Hawaii, or another state with strict carry rules. You see a viral post saying, Supreme Court ended permits, carry now. If you trust that post instead of your actual state law, here's what could happen. You get stopped. You are carrying without the required permit. You tell the officer, I thought the Supreme Court got rid of permits. That will not save you on the side of the road. That is why headlines can be dangerous. Third thing, Bruen changed the legal test courts use in gun cases. Before, many lower courts balanced rights against public safety arguments in a way gun owners often lost. After Bruen, the court said judges must look at the text of the Second Amendment and the nation's historical tradition of gun regulation. That sounds technical, but here's the simple version. States now have a harder time defending some modern gun restrictions if they cannot point to a similar tradition from earlier American history. And yes, that affects more than permits. It affects future cases too. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. But wait, there's something even more important. Just because a state cannot demand special need does not mean every other permit rule is automatically valid forever. It also does not mean every other permit rule is automatically dead. Each rule has to be looked at on its own. That means some training requirements may survive, some fees may survive, some background checks may survive. But if a state uses delays, vague standards, or impossible hoops to make permits hard to get, those rules can still be challenged. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the people who get these updates first before bad information spreads everywhere. Click subscribe. Now let's talk about what this means for every state, because this is the part nobody is explaining clearly. First, if your state is permitless carry, Bruen did not force you backward. Those states were already allowing carry without a permit in many cases. The ruling mostly gave more support to the idea that ordinary people have a right to carry outside the home. Second, if your state is shall issue, you probably still need to get the permit if your state requires one. Do not assume the form, class, or application process disappeared. This is where people get burned. They hear Bruen and think, my permit no longer matters. Wrong. In many states, the permit still matters for concealed carry, reciprocity, and avoiding criminal charges. Third, if your state used to be may issue, that is where the ground shifted the most. Those states had to stop treating carry like a favor for the privileged few. They had to move towards systems based more on objective criteria. That is a major nationwide impact, even if the details look different from state to state. Fourth, Bruen did not create national reciprocity. This is a huge myth. National reciprocity would mean your permit from one state works everywhere, kind of like a driver's license. Bruen did not do that. So if you travel, you still need to check the law in every state you enter. Here's a hypothetical example to explain this. Let's say you have a permit from your home state. You drive across 3 states for a family trip. You watched one video that said, Supreme Court ended gun permits. You assume your permit does not matter anymore, or that every state must honor it now. That assumption could get you arrested in a state with different rules. Not because Bruen was fake, but because your understanding of it was incomplete. Fifth, Bruen did not erase sensitive place restrictions. States still argue over where guns can be banned. Airports, courthouses, schools, and certain government spaces are still major legal battlegrounds. So do not make this mistake. Do not think the case means you can carry anywhere you want. And here's the part that surprised a lot of people. After Bruen, some states responded by naming huge lists of sensitive places. In other words, they lost the fight over who gets a permit, then shifted the fight to where you can carry once you have one. That is why the story did not end with the Supreme Court opinion. Now, this is where it gets really important for the future. Bruen is not just one case sitting on a shelf. It became the foundation for many new lawsuits. Gun owners started challenging bans, permit rules, waiting periods, and more. Some won, some lost, some are still being fought out. So when you hear people say, the Supreme Court ended gun permits, what they are really doing is crushing a long, complicated legal shift into one catchy sentence. And catchy sentences can cost you. If you want the safest, smartest takeaway, here it is. Bruen ended discretionary special need carry permit systems. It did not end all permits. It did not make every state permitless carry. And it did not give you a free pass to ignore your own state's carry laws. This information could literally change again as new cases move through the courts. Subscribe now because the next video explains exactly what changes gun owners should watch before the next major ruling drops. So what should you do right now? First, check whether your state is permitless, shall issue, or still fighting over old may issue leftovers. Second, if your state still requires a carry permit, do not stop renewing it just because somebody on the internet yelled Supreme Court. Third, if you travel, check reciprocity and sensitive place rules before you cross state lines. Fourth, stay alert, because states keep rewriting laws after losing in court. That is the real lesson here. The Supreme Court did not end gun permits across America. It ended one powerful excuse states use to deny ordinary people the right to carry. That is a big deal. But it is not a magic wand. If this video saved you from believing a dangerous headline, subscribe right now and share it with one person who needs the truth before they make a serious mistake. I want this channel to help you stay legal, stay informed, and stay one step ahead of bad advice. And of course, simple disclaimer here at the end, this is general educational information, not personal legal advice. Gun laws change, court fights continue, and your exact state rules may be different. So talk to a qualified attorney if you need advice about your own situation.